My Lord, I'm in section 4 of my skeleton argument, dealing with the first 2 grounds of appeal to this court.
Hang on 1 second. My Lord, my Lady, and I have had a discussion over the adjournment. We will proceed, unless we, in due course, hear submissions to the contrary, on the basis that if we have to consider justification, the authoritative place where the justification will be found is in the terms of the dismissal letter, which is effectively, forensically, the approach that you took. And we don't need to hear more from you about that, Mr. Jones, about what the grounds of justification are, unless you want to address us on it when you come to your submissions.
No, I'm very well.
Okay.
My Lord, thank you.
Yes, sorry, you were saying,
So
grounds 1 and 2, your skeleton arguments.
Section 4 of these submissions.
Yep.
And I was already in that material talking about whether the matters advanced, for example, in the letter of dismissal, were a reasonable proportion
yes.
of the union got, and so on. So I ended with a reference which to some extent escaped me to the case of Sahin and Turkey. But I do want to take you to that now because I think it's quite important. So if you could turn to volume 4 of the authorities bundle, and the page to which I'm taking you is page 144, 143 to 144, and paragraph 107 of the court's judgment in that case.
This is the one you cite in your skeleton argument.
I do.
Does it need context? It's 1.5 lines of quotable words.
Of course, context may always be helpful to a reviewing court, and no doubt you will tell me more about the context in a moment. But I would simply say this: whatever the context, a clear and unqualified statement of principle, which is itself attractive and has been adopted in other cases, has force, even if the context is very different.
Well, it's really the same points I made to you this morning. Insofar as there are, as it's appropriate to look at the issues in very broad terms, and actually there's some quite complex points of legal analysis here somewhere. But insofar as we're looking at it in broad terms, you don't have to persuade us of the importance of the principles of freedom of speech.
No.
And there are dozens of authoritative and persuasive statements about that. But the question is how far or how it applies in a particular case, given that it can never be unqualified. So see why you take us these general statements of principle, but we really don't need to be reminded of them. They're all in your skeleton argument. Speaking for myself, and I'm sure for my Lord and Lady, we take them extremely seriously.
I'll just simply then emphasise that these 3 words, 4 words, before moving on: the duty to foster toleration, which is set out in that part of the judgment. I come now to the question of mode of manifestation, which is clearly important in this case, and is important in many cases. Very common for a respondent to say what we objected to, sometimes perfectly genuinely, was the mode of your manifestation and not its substance. In this case, the school did indeed take objection to the language in which the posts are expressed, and in paragraph 30 of its judgment, the Employment Tribunal held, in effect, that that because the school would have allowed her to express their views, or so they said, if they'd been expressed in a very sanitised view, and the example of sufficient sanitisation was the pleadings, because that was so, then there was no breach of duty on the part of the employer. In my submission, this was a serious error which was repeated by the Employment Appeals Tribunal when considering the matter and deciding against the respondent, the appellant, on this ground. And the reason why that is so is that...
Well, show us the passage. Sorry, I don't know why you're keeping taking us to the Employment Tribunal, whose reasoning has been overturned. It's the Employment Appeal Tribunal we're interested in, and only on those points where they were against you. Yes. So, which is the paragraph in the EAT that you say was wrong?
So, let me just... just have to back.
Well, if you're not challenging some part of the EAT's reasoning, we can move on.
No, we are challenging.
Well, can you show us which part?
Okay.
I mean, the paragraph that constitutes the President's guidance to the Tribunal on remission is paragraph 94. Anything else, she says, up to that point isn't really, doesn't really bite. And therefore, which of these propositions are you challenging, the 5 propositions there?
I'll put it this way. It was a ground of appeal to the Employment Appeals Tribunal that the ET had misapplied ECHR law when holding that it would be okay if the posts had been expressed in a sanitised way. The EAT records that challenge at paragraph 63. And the EAT's response to the challenge is found at paragraph 73 on page 75. And it's more clearly put in paragraph 80.
Well, 73 isn't.
Yes, it's
70 is simply recording a respondent's submission.
Yes, I beg your pardon. If you go to paragraph 80 on page 279.
Got paragraph 80. What are you saying is the ruling here, which is wrong?
Sorry, it's not. I'll have to come back.
Mr. Adair, yeah. We've got to focus on the issue. You are saying that the Employment Appeal Tribunal was wrong to remit. That is your primary point. wrong to remit because on a correct direction of law, there was only one answer on the facts found.
Yep.
Yes?
Yep.
Secondarily, and alternatively, you're saying even if it was right to remit, because there were points that still needed to be considered by the ET, there were some wrong directions, if that's the right word, wrong guidance given to the ET as to the scope of the remission.
Yes.
Those are your grounds of appeal, aren't they? And I really only think we need to focus on points that are relevant to that. So the focus really underlying that is a general question about what the correct test is.
Yes.
But so far as that is concerned, as I understand it, you say, well, there's no issue on this appeal, that the effective page is that effectively a proportionality exercise is required.
That's right.
And therefore we're only concerned with any errors in how the EAT gave guidance as to proportionality exercise.
You're concerned with guidance, but you're also concerned with whether, given the law as it is, the ET could properly have found that the interference was justified.
Well, that's the first point. That's your primary point, yes.
Yeah. So the point I'm making now is this, that it's highly relevant to the proportionality exercise that case law, specifically but not solely ECHR case law, grants a high degree of latitude to those exercising Article 10 rights in terms of the mode and manner of their manifestation.
There is clear authority that you can be intemperate. And you don't lose in your political speech, and you don't lose protection as a result. Speaking myself, I think that's clear.
So, thank you.
Might your point be, if there is an additional point that is not brought out clearly enough in paragraph 94? Because if I've understood it correctly, ground 3 isn't really returned to. Ground 3 of the appeal to the EAT.
As I understand it, I'm afraid I can't find the reference in the moment.
Yeah.
The EAT specifically affirmed the finding of the ET that if only she had expressed herself in the sanitised way found in the pleadings, that would have been okay. And that can be viewed as a self-standing matter or as an aspect of the proportionality exercise.
Well, that might be wrong, but so what? The question is, the proportionality question is, was it proportionate to do what the respondents did in the light of the posts as they were? Not had they been expressed in the manner of an employment tribunal pleading, would that have been grounds for dismissal?
Well, it's simply this, that we are concerned with the actual grounds of the tribunal on this second appeal.
Sorry, Mr. Adair, just in case it helps you, I think the section that you haven't located may be at paragraph 85.
Thank you, my lord.
Which does address ground 3.
Yes.
don't see much in here.
I'm grateful to my
I don't
lady.
see much in here you can object to.
Um,
It's not saying what you're saying you were saying.
It's right that the EAT refers there to all the relevant authorities. It is simply, as we have said, that the EAT manifestly failed to apply them to the finding of the ET in this case, which was that if only you'd expressed it in the sort of language of the pleadings, that would have been fine. That's paragraph 30 of the employment.
Well, I don't see any positive endorsement of that. I'm not even quite sure that's a fair description of what para 30 said. Aren't we going around the margins of a marginal point?
No.
Rodair. What? Forget what exactly the ET said and what the EAT said. What do you say the law is that we ought to make clear?
The matter that you should make clear is that, as set out in the judgment of Mr. Justice Knowles in Miller and College of Policing, speech does not lose protection because it's opaque, profane, or unsophisticated. And I
don't think you'll have any difficulty persuading us to say that, though I don't think there's anything in the ET and EAT decision that means that we need to say it.
So but I do submit that if that law had been applied to the position of the appellant, the case would have been decided in her favour.
Yeah, well, that's your primary submission, and we've got to consider whether that's right.
I'm sorry to have laboured the point.
What do you say about paragraph 91 of the residence judgment?
I'm sorry, I just couldn't hear that.
Paragraph 91
Of
of the EAT judgment says the appeal should be allowed. This is not a case in which it can be said that only one outcome is possible, and so I have to remit. And if you're trying to persuade us that that was wrong, don't you have to look at paragraph 91 and tell us what's wrong with it?
What was wrong with it was that if it had, and if the ET were to, and you do, look at the facts of this case, there was only one answer. And if there is more than one answer in my submission, that is very concerning, because it involves a step back from the long-held commitment of this legal system to the cost of freedom of speech.
Right, where do we go now?
Where do we go now? Right. Let me just... I want, before leaving this part of the submissions, to just refer very briefly, and I know why it has to be brief, to the submissions of the various parties on the wider conceptual structure
Yes.
of the law in this area. It's our submission, and I can put it this way in order to keep it brief, that for the most part we are in agreement with the submissions of the Free Speech Union. Mr. Cooper's very clear and helpful submissions. It's said that, for example, by Miss Clement, I think she's going to say, that the ECHR is irrelevant to the proper understanding and application of Section 13 in belief cases. That, however, and this is Miss Clement's view, nevertheless, Section 9 protects not only belief.
Do you mean Article 9?
Sorry, no, I mean the relevant section of the Equality Act, which is.
Oh, sorry.
Section
10, sorry. Section 10 of the Equality Act. Protects not only beliefs, which is the word used, but also manifestations of belief. And in my submission, that is clearly right. It was the conclusion of Mrs. Justice Eadie in this case. And it was also the conclusion of the ECJ in the case of Bogdanawi and Awi and Metropole, as it was put by the Advocate General in that case and also by the court.
But this isn't controversial either, is it?
It's not controversial between myself and Miss Clement.
Is it controversial between you and Mr. Jones? Well, at the moment, I'm not really asking Mr. Jones to jump to his feet, but I'm just trying to understand what issue you think you're
I think the issue I'm going to go to is this. Though it's in my favour, such a view does raise a question, which is, are there any limits on manifestation of belief other than Article 17, which is obviously very extreme? How do we know, if it's not all of them, which manifestations of belief are protected by Section 10?
But isn't there case law about what the limitations are on?
There is, and it's largely, well, apart from, there's Article 17 stuff, obviously.
Well, I know you said not apart from Article 17,
but the rest of the case law comes from, for the most part, the ECHR, because it's the ECHR which has had to grapple, as a result of the structures, of Article 9 and 10, with limits. And so the difficulty that arises from Ms. Clement's view is, well, which manifestations of belief and how do we know, leaving aside Article 17 cases? And Mr. Cooper, very neatly in my submission, says that in working out which manifestations of belief are protected, you also deal with the conceptual problem arising from separability. Once you've determined which beliefs are protected, then it follows that any action taken by way of those manifestations of belief is unlawful. So everything turns on an identification of which manifestations of belief count, and once that is decided, you have a solution to the separability problem. And everything after that can happily rest on causation. So, in my submission, the way that Mr. Cooper laid out the law has the huge advantage of transparency. It sets into the mode of analysis a consideration of the inevitable value factors arising in this area. And then, after those matters are played out, matters can be left as normal to the question of causation. If the detriment was caused by protected manifestation, then of course it's unlawful and separability is logically impermissible. So those are my submissions on that, which I keep very brief because we're not logically here to decide that. But my Lord mentioned before lunch a desire, if possible, to set the case on a clear, defensible, conceptual footing.
Yes.
And in my submission, Mr. Cooper is a trusty guide.
Thank you.
In that journey.
Reread him with knowing he has the advantage of your endorsement.
I'm sure he is not feeling cheered by that. So by your desire to read, he will be, I'm sure. Onwards, I've got probably 35 minutes left to section 5 of my submissions, which covers grounds 3 of the appeal and is all about stereotyping and responding to third-party pressure. The starting point for the law in this area is the judgment of Lady Hale in the case of Roma in 2005. And that is found in...
I think it would help me before we go to that, because again, these are fairly familiar cases. What part of the EAT's reasoning, I'll start again. Let's take your primary case that we ought to have found, we ought to find, the EAT ought to have found, and therefore we ought to find that there was only one answer to this.
To the proportionality.
To the proportionality question. How does your stereotyping submission fit into that? What is the proposition?
I'll take those points one at a time. It fits into that in more than one way. It fits into it for a start.
Sorry, it's my fault. The question I meant to ask is, what is the proposition?
Right. The proposition is this. That to have as one's reason for treatment, dismissal or whatever, an assumption about the claimant derived from his or her protected characteristic is to discriminate against the claimant.
Yeah.
Now, it's fair to say that I don't anticipate us being... Sorry, I'll start again. I also wanted to say that the reason this is raised is not just as a separate ground, but as part of the proportionality exercise.
Yes.
But not only that, because in my submission, if the appellant was the victim of a stereotype and the respondent is responsible for that, and we'll come to that in a minute, let's put it as a stereotype by the respondent. That is itself an act of discrimination.
It's just an overcomplication. if she was dismissed for manifesting her political beliefs, then you get home. If she was obviously dismissed for that reason, then you get home. What's added by this stereotyping point?
In many appeals and in many lawsuits, there are alternative arguments
Yes,
which lead to the same point.
okay, well, I'll let you develop it.
So, in terms of the law, the law is set out, as I've said, in the well-known judgment of Lady Hale
Yes.
in the Roma case. Do you want me to take that at this stage?
Speaking for myself, not. It's in your skeleton argument.
Right, fine, that's absolutely fine.
Just give us the paragraph reference in your skeleton. That's all we need.
78.
Thank you.
So, glass of water. Excuse me, sir. In my submission, as you've indicated by way of your desire not to be taken to it, that the law on stereotyping is important, is well known and unlikely to be disputed in this court. What's at issue is its application to this case. And the reason why it's at issue in this case is because it was a separate ground of appeal to the EAT that the claimant appellant had been stereotyped, but it was not dealt with at all by the EAT. The EAT recorded in its judgment that various further grounds, of which this and the next one are examples, had merit, but they didn't need to be examined. And we say that was an error of law because they provided, these submissions, an alternative means of getting home.
I see. Is your point this, that if they had been dealt with and had been found in your favour, there wouldn't have been a remittal, there would have been a decision there and then in your favour?
No. And in this court also,
therefore in this court also.
Yeah. Okay.
Yeah, okay.
And the basis, of the factual basis of the stereotyping argument was the belief that the claimant was a threat to LGBT pupils because of her beliefs. And I've already been through the fact that there was no evidence that she was a...
Yes, well, you've made your points on that, yes.
So the question is, if that was a stereotype, is the appellant respondent responsible in law for it?
Yeah.
And you will see when you look through the letter of dismissal that at various points the respondent, Mr. Conlon, seems to be saying, we think she's a menace because of her beliefs. And at other points, he seems to be saying, the parent thought she was a menace because of her beliefs, and so we take action. Of course, if you hold, looking at the text, that the school was in fact holding that for itself, then we will succeed if you think it's a stereotype. If not, if it was the the parent who held these stereotypical beliefs, then the question is, was the school responsible in any way for the parents' discriminatory views? Now, again, the law in this area is pretty well accepted, and by happy coincidence, it's found in the same paragraph of the Römer judgment. For example, it's well accepted in this jurisdiction that if, say, in a school, a parent or parents make clear that they don't want their child taught by a teacher of a particular race, then that, as Lady Hale makes clear, will be discrimination by the school, because they are adopting the discriminatory reasoning of the parent. What has not been done so far is to explore the application of that principle to a case involving religion or belief. And it is a very important exploration because it is sometimes the case, and is likely to be the case in future, that the parents or customers or staff of a respondent take objection to the beliefs of a particular member of staff. They may make life very difficult for the employer. But what I say is clear as a matter of law is that it is no excuse for taking discriminatory action or action based on adopting discriminatory reasoning of a parent, customer, whatever, so as to advance the school or business or whatever. You simply can't justify discrimination on the basis that third parties want you to act in that way. And that's as true of religion or belief as is of race. How does that apply to this case? In this case, there was only one person who raised the question of the claimant's suitability to work with children. That's the parent. It's clear in her complaints that she wanted action taken against the claimant and that she was stereotyping the claimant. And we say that the school was essentially adopting the discriminatory views of the parent as a reason for action. And if we're right on that, and that very much comes from the letter of dismissal, then it follows, we say, that the claimant was entitled to judgment, and her appeal should be allowed in this case, regardless of the proportionality exercise, which is another avenue to success. I come now to ground 4, which is section 6, ground 4 of my
yes, thank you.
skeleton. I can take this relatively quickly. My Lord, you're already aware through your reading of the papers that there were 4 claims, in this case 4 alleged acts of detriment stroke dismissal. Which of these succeeded mattered, not only as a question of principle, but for other reasons. As you've said, it might be possible for one ground to succeed, another one not to succeed. And it was also important in relation to the running of time, which doesn't necessarily it's not necessarily obvious in this case, but it was important in this case that to establish the best possible position on the running of time, that the outcome of the dismissal should be an act of discrimination.
Well, of course, I mean, It's not so much that might be thought to be secondary. That's obviously the primary. That's obviously the primary complaint.
Yes.
What I was just wondering about is how much difference it made in practice to bring in the prior complaints.
I thought about that over lunch, and it seems to me that logically it ought to be possible for the respondent to succeed on suspension and investigation and not on dismissal. If that was the case, then of course most but not all of the loss would flow from the dismissal in terms of financial loss. Unless you were minded to find that, as has not been made the subject of a respondent's note, unless you're minded to find that the investigation and the suspension were obviously lawful, there would be a remittal back on those two, or whichever two were found to be possibly successful, and not on the others which were inevitably going to succeed. Now, pragmatically, one might hope in that situation that the parties would focus on what really mattered, which was the dismissal, and that a remedies hearing would be scheduled to deal with that. But even if that wasn't the case, then the position would be that at a subsequent hearing, the potentially successful justification defences will be considered, and then on the same day a remedy hearing or something like that. It's not beyond the bounds of judges and lawyers' ingenuity to deal with it in a pragmatic way, if that's how things come out.
Thank you.
The claimant's, the appellant's position on this matter is that the justification which found its way into the appellant's, a respondent's letter of dismissal and the ET's judgment emerged only during the cross-examination of Mr. Conlon, who was the dismissing officer, by Employment Judge Reed, starting at page 52 of the supplementary bundle. It's worth noting something you've already addressed in part, which is this, that the justification on which to which the ET acceded was not found in the pleaded case before the Employment Tribunal. My Lord Justice Bean has made that point already. It would not have been, we say, open to Judge Reed to go to the pleadings and say, "Ah, yes, that's the justification." Now that is important because the evidence on which Employment Judge Reed had was found only in the cross-examination of Mr. Conlon at the end of his evidence. In other words, similar questions, similar answers were not given by those who conducted the appeal, the investigation, and so on and so forth. In its judgment, the Employment Appeals Tribunal held, this is at page 80, paragraph 80, that the employment judge was entitled to conclude, looking at all the evidence, that somebody somewhere had explained matters in this way. We say that cannot be right, because in effect it removed from the respondent the obligation to indicate through the appeal process what was the evidence, and we know it doesn't have to be very much, to rebut a challenge of this kind.
So are you effectively saying, does your submission amount to saying that there would have been no evidence there was no evidence as to this being the reason in any of the earlier stages?
Well, we don't know. I mean, and
well, but you isn't that what you would need to say? Because this is a finding of fact.
It's a finding of fact, but the process in my submission works like this. Well, no, let me put it this way. I'm sorry. It was our case that whilst the investigation officer and the dismissal, the appeal officer and the suspending person, it was our case that they obviously gave evidence about why they did what they did. But they didn't.
Sorry, is that I wasn't aware of that. So each of the, if so, I hadn't taken it in. The person who made the decision to suspend, and the person who made the decision to bring charges, and the person who conducted the appeal, all gave evidence.
Can I just check to make sure that I'm right about that? Because obviously I wasn't there. Is that right? That is right.
Okay, sorry, I hadn't taken it. And all, therefore, there will be witness statements somewhere saying this is why I did what I did.
Yes.
Have we got those?
No. I mean, it's not the appellant's job to, when there's a challenge of this kind, the respondents can defeat it relatively easily by showing a scintilla of evidence which supports their claim.
Well, I think for completeness, I, of course, am very alive to the risk of relying on anything said in witness statements where there has been oral cross-examination. Nevertheless, I think in order that we have a complete view of the case, I think we should have overnight the witness statements of the respondents' evidence.
Yeah, absolutely.
Witnesses. Okay. But you say we will find nothing in there that is evidence of justification.
Yeah. Well, no, as evidence of this ground of justification.
Which ground?
The reasoning found in paragraph 63 of the Employment Tribunal judgment. The reason that by reason of the posts, a reasonable third party might think that the claimant was homophobic.
Yes, I see.
To be clear, that judgment, that evidence was what found its way into the judgment and underscored the difficulty, and underscores the reason for the dismissal. I would just say on this that it is a respondent's duty, if it faces an evidence challenge, to provide the evidence which they say formulated and led to the
well,
finding.
maybe.
And the other point to make about this, in case it's seen as a trivial point, which isn't, partly because of the time point and the continuing discrimination which we say flowed from the appeal rejection, it's manifestly right that if A, B, C and D are said to have discriminated, there should be separate findings in respect of A, B, C and D.
Yeah.
And that would be particularly so if A, B, C and D were found to have discriminated. It would be outrageously unfair under those circumstances to say, well, C said the reason for the treatment was this, therefore they all had the same reason. Clearly not right, and clearly not right either when the the finding was of no discrimination. Excuse me a moment. You'll note in my skeleton argument, and I'm not going to go through it now because time is passing, that we say, on the basis of the evidence there set out in the skeleton argument, which refers to the core bundle, we say that the not only did the ET err in failing to make separate findings, if it had made separate findings, it would have been bound to find that they had discriminated. And there are various, we say, hugely telling, damning admissions on that subject set out by the in my skeleton argument. Now again, it may be the case that the respondents say, oh well, there must have been other evidence to show that however matters appear from these extracts, and you can't cherry pick, which I accept, but there must have been other evidence to show that these people weren't discriminating. Well, this point was run in the EAT, and the EAT has a process for respondents to deal with findings which are in whole or in part based on evidence. And it is that you submit the evidence you say shows to be such as to support the findings. That was not done in this case, as far as I'm aware. Yes, that was not done in this case. So, but we do rely on those paragraphs to show that not only did the ET err in law in failing to make the findings, but that if it had made the findings, it would have found that those individuals had discriminated. So, I come now to deal very briefly with some wider matters identified in particular by my Lady Justice Lang in the various procedural stages of this appeal. I've already addressed you on the conceptual structure of section 10 and 13, as we say it ought to be. And the only other two issues I want to address you on is the question of whether reasonable perception of others is a matter capable of justifying discrimination, because that is what...
I thought you'd already submitted that it wasn't.
The final thing I want to come to then is the question of guidance, very briefly.
Yep.
Just let me say one sentence about that one. To say that the reasonable perception of others is a matter capable of justifying interference seems, in my submission, to amount to saying that those exercising Article 9 and 10 rights have to take care not to be misunderstood and not to cause offence. In my submission, that is an unfortunate and potentially dangerous erosion of the position that the law has taken on freedom of speech. There is nothing, as far as I know, in the ECHR case law that says that there is some kind of duty to speak so as not to upset others. for example. I come lastly to the question of guidance. Guidance was given in this case on the basis of the submissions of the Archbishop's Council. It's our submission that the guidance which should be given is not that of the Employment Appeal Tribunal. It is...
When you say guidance, are you referring to paragraph 93?
Yeah.
That one with the 5 points in it, yes. Which bit, rather than a generality, which of the points you say are wrong?
I will... it is what it doesn't include as much as what it does include.
I see, okay. So you're saying that, I don't want to put words into your mouth, but am I right in saying that you accept the guidance in 93 as far as it goes, but it should have included also ...
Can I just...
Sorry, I say 93, it's 94.
I think, in my submission, that whilst on the face of it, some of it is unexceptional, nevertheless, it needs to be reformulated and rewritten so as to emphasise the most important aspects of the law on this case, all of which stem from the crucial importance of protecting freedom of speech at a time when it is under threat. The threat being exemplified, for example, the facts and matters at issue in Miller. And that what freedom of speech needs is some strong boundaries so that people can know where they are. Because that is, in my submission, the problem with the submissions of the Archbishop's Council, which were carried over and largely accepted in Mrs. Justice Eadie's judgment. The problem is that there are so many factors to be taken into account that it becomes very difficult for people to know where they are. I also argue...
So are you really getting at subparagraph 5? Some of the contents of subparagraph 5?
Yeah.
I think you are.
That's right.
Too multifactorial.
In addition, the guidance does not emphasise sufficiently strongly the principle that freedom of speech should not be restricted where others are offended by the speech. The guidance failed to emphasise the need for alleged feared harm from speech to be evidenced and to be clearly distinguished from distress, stroke upset. In addition, counterfactual arguments by respondents, we would have tolerated the speech if only she had reformulated in this way, or been in this place, or used this language, should normally require evidence of counterfactual conduct, i.e. Genuine toleration of the claimant's views. Finally, I would say that a concern with offence cannot be repackaged as a perceived need to feel safe, or without evidence to protect vulnerability.
Well, you're trying to smuggle in a completely different issue, which you mentioned in your opening about academic free speech.
I think
there's nothing here about need to feel safe. And
no, that's true. But guidance.
Yeah, I think we will take a lot of persuading to give some sort of universal guidance.
Well, I understand.
Subject as Mrs. Justice Eady herself said, there are just too many different fact situations. But certain particular points may be relevant to the particular exercise a particular tribunal has to do on remission, and that's what she tried to do in '94. But putting in points about need to feel safe, I think is irrelevant in the case of this trial where it wasn't relied on.
I had on my list a couple of points to deal with in the respondent's skeleton in relation to causal arguments, but unless you direct me to the contrary, I think I may just wait until they see.
You're always entitled to deal with respondent's points in reply. Might well, in this case where the shape of the issues hasn't yet clearly emerged, be wiser to do that. But if that's your choice anyway,
Yep.
it seems sensible.
I appreciate that. May I just take instruction?
Yes, of course.
My lord, my lady, those are my submissions.
Thank you very much, Mr. O'Dowd. Yes, Mr. Jones.
Thank you, my lords. Can I start with the conundrum that you face, which is this? There are two issues before you. The first is whether or not, on the assumption that the EAT read the Court of Appeals decision in Page correctly, they should or should not have remitted the case.
Yeah.
The second is whether the guidance that the EAT gave whilst making the remission was correct. And it's in relation to the latter of those two issues that the interveners are here principally, either in person or in written submissions, to address you on.
In practice, the substantive issues underlying both points are the same, aren't they? We have to understand what the principles are and therefore what guidance emerges from them, which is the second question, in order to answer the first.
We agree.
Yeah.
Which, of course, is one of the reasons why we sought leave to cross appeal, but we were not given leave.
We are where we are on that.
I find myself in somewhat difficult position. This is what I understand it to be. So I'll describe.
So this is what
I understand our position to be.
Yes.
We're not in a position to invite you to directly, at the very least, to overturn the remission, or directly to overturn the guidance. But we are, as I understand it, entitled to respond to the submissions which are being made by the interveners. So,
well, only insofar as they're relevant to the issues in the appeal.
yes, but the appeal includes, as I understand it, on the part of Mr. Adair, criticism of the scope of the guidance which has been given. So that's
Certainly,
part of his
yes,
thrust.
certainly. But just to be frank about it, we've got to decide what the scope of the appeal is. It might be thought, and I make no particular criticism, some of the interventions raise points which really aren't within the scope of the appeal. And you can't, I'm sure you wouldn't intend to do this, you can't say, well, we can't take this point, but some of the interveners have, and therefore we can comment on them. Perhaps I'm sure that wasn't what you were saying, but I just wanted to
Maybe,
make
to
that
some
clear.
extent what I'm saying, at least I certainly would be saying we very much like the submissions which have been made on behalf of the Commission, for instance. But
Yeah, well, it's a difficult situation for all of us. In the interest of rigour, I think it's important that I say what I've just said.
Yes.
Having said that, there are important general questions about the scope of page. We're bound by it. And I don't think you'll find me or us stopping you giving us some help about how page ought to be interpreted. And if that slips over occasionally into saying page is wrong, we won't be saying page is wrong, but it may be a context for narrower points that you are entitled to make. I'm not making myself very clear, am I? But
perfectly clear. At least insofar as you're unclear, I share that lack of clarity. It's pretty much what I was going to propose. So can I just say?
Well, let's just take it by ear. We'd like to hear what you have to say. If you are going too far off piste, we'll tell you.
I'm very grateful. Can I make it clear right from the start that for two reasons you're going to hear both from me and Mr. Milson. The first reason is that I'm not well at the moment, and he's very kindly agreed to bear some of that burden. It's just a cold. I'm not about to expire. But the other reason is, as you probably know from experience, in terms of how the brains are distributed in this particular team, it's likely that he will be of greater help for you in dealing with some of the commission authorities that we're going to have to turn to. So can I describe what we propose?
Well, I'm sorry. Firstly, I'm sorry you're not well, but if you assure us it's not such you can't address us at all, we'll of course accept your assurance on that. That's fine. Beyond that, of course, divide the submissions up as you wish.
I'm very grateful. So some of what I'd propose to say to you, I think I can probably skip in the light of the interaction that has taken place in the course of the previous set of submissions.
Well, let's hope so, but don't take anything for granted. I've been exploring points. I may have expressed some provisional views, but don't skip too much.
No. Well, it wasn't so much the exploration of the points as my first intention had been to take you in some detail to the ET's decision, and it's clear that you're probably not going to want me to do that in any great depth. But I will, if you don't mind, spend a couple of minutes just pointing to the factors that we say are going to be important for the grounding of the arguments.
Yes, of course.
Once we've done that, the next section heading would have been, what did the EAT determine the ET has got wrong? But I suspect that is clear to you already in the light of the reading of the decision. Then I was going to spend a short period of time looking at the scope of the remission, not for the purposes of challenging it, but because when one looks at the order for remission, it surfaces very clearly the problem, what one might call the page problem, that is going to be the subject of the broader submissions, put before you by the interveners, and what both of the parties to the appeal have to say about those submissions. Then I was going to move on to address directly the grounds upon which the appellant says the matter should not have been remitted, and after that deal with his remaining grounds. At that point, I would yield to Mr. Milson, and he would deal with the approaches suggested by the other interveners insofar as he consider in due course
As we let him, yes. Good.
So can I
Sorry, I didn't make a fuss about it this morning, but we had... Yes.
May I invite you then to start with the tribunal's decision, which is at page 94 of the core bundle. And I think I should be able to move through this at some speed. And the first thing to note that this was a case which was run as a Section 13 case, as a direct discrimination case. My understanding is that there was at one point an indirect discrimination claim, but there was an issue as to whether or not that had been commenced in time, and ultimately the tribunal did not hear it. And the reason why I raise that is because in due course, when you're hearing submissions from the interveners and others about how best to deal with cases which are concerned with the manner of manifestation, one possibility, of course, is that they're dealt with as Section 19 cases. And certainly one principle that you'll have to take into account in determining whether or not the Equality Act and the Convention rights, whether the Equality Act can be interpreted in the light of the Convention rights in a manner which is appropriate, is you'll have to look at the whole of the Act, not just Section 13. So one of the problems I think about this case and the consideration of the page and the Convention issues is that one must be careful not to think about whether or not the Equality Act conforms with the Convention principles solely through the lens of Section 13, simply because it happens to have been a Section 13 claim which has been brought. So that's a point which will be developed not by me, but by Mr. Milsom, and I see it's a point which is at the heart of the submissions which are being made on behalf of the Commission. So it's just a question of keeping one's head up, as it were, and looking at the broader horizon of the Act when looking at the question as to whether or not the Convention's rights are being respected. So it's the Section 13 claim they consider. They tell themselves in terms, at paragraph 34, that they're bound to interpret the Equality Act consistently with the ECHR, especially Articles 8, 9 and 10. They find that a number of the beliefs, A to E at paragraph 30, are protected beliefs, and in fact go further in their first instance decision than then Employment Judge Taylor was prepared to go enforce data. And they're very clear, they direct themselves, you'll see this at paragraph 42, which is at page 100 of the core bundle, but the mere fact that people might find the beliefs offensive did not mean that they were not protected. So they lead with that. They then go on to say at paragraph 52, at page 102, in dealing with this question of the significance of where the messages were posted, that they, the tribunal, did not consider that the claimant had any real expectation of privacy in relation to matters that she had chosen to publish in this way. The school was fully entitled to take action in relation to the posts.
So, sorry, where are you reading from?
So, paragraph 52 at page 102 of the core bundle. It's the last sentence of paragraph 52, which is at the top of the page, 102.
Yes, I suppose that's directed to Article 8 points.
Yes, but also it will have some relevance, as I understand it, to the question of proportionality, if in due course it has to be considered.
Yeah, but just the terms of, yes.
And it's also a matter, of course, that Lady Justice Lane had in mind when she was dealing with the petition to appeal, the significance of where these messages are.
Just, sorry, a small point, but I don't want to say anything ignorant in our decision. Is the ET right to say that the only way in which Mrs. Higgs' posts to her friends could have been given wider circulation would have been by screenshots and then recirculation?
Well,
I had thought that a friend could actually simply repost.
Well, I agree, and I heard Mr. O'Dare accept that in terms earlier today.
Yes.
So, if anything, they've rather underestimated the extent to which she's foregone privacy.
Well, that must apply to just about any communication, any social media posting, any email or text, save one sent to a tried and trusted individual or family member. Anybody else can send it on to anyone.
It does, as a number of barristers on Twitter have discovered to their pain and embarrassment,
Yes.
not naming any particular names at this point. And it has to be borne in mind that social media is effectively a broadcast medium. So it's not like writing someone a letter or making a phone call. Yeah. It is publicising to one extent or another what it is you set out in your message. And you'll no doubt be familiar with the concept of messages which may not have been intended to, so-called going viral, where the point of a social media network is that it is a network. And it produces a network effect, so that if you copy to one person, they copy to two persons, and then those two copy still further, very quickly you get effectively exponential growth of sight of the message that you have sent. Very often that's what people are looking for. If they want, for instance, let's say they want a petition signed, they want as many people to see it as they can.
Right.
And this is where social media is, to my mind, revolutionary. Is previously, if you wanted to do that, you had better know the editor of a newspaper or someone who was a TV producer, or be in a position to engage in a stunt that was sufficiently newsworthy that someone would give
Sorry,
you attention.
Mr. Jones, you're talking rather quietly, and I'm rather old.
That's what I'm saying.
It's probably your cold. If you could bear to speak up a bit more, I can just hear you, but not very easily.
I'll up the volume.
Thank you.
So what social media does now is allow people who wouldn't otherwise have had access to channels through which to reach a wide audience to do exactly that. Sometimes they will be trying to do that deliberately, but sometimes that's something that happens to them without them intending that it should. But anyone who's engaged in social media knows that that is something that can happen. And particularly in relation to Facebook here, it's clear that the tribunal appreciated that that was something that could happen, such that she couldn't have had an expectation that anything that she published would be private in any meaningful way. And I mean, one has to bear in mind that one of the things which is said on her behalf is one of the reasons it's important to provide a broad and deep protection is this is her engaging in the political sphere. It's a political statement. She says, participating in politics more broadly, not simply a note to a friend.
I suppose it's maybe a marginal point. The point could be made that if it is posted beyond the range of her friends, the wider audience are much less likely to know that she has anything to do with the school.
Yes, that might be right.
Some of the 100-odd friends we're told did know who she was, because, although she was using her maiden name, and did know she was associated with the school. But that wouldn't be so on a reposting unless someone, hard to see why they would, had added, by the way, this comes from Mrs. Higgs, who works at such and such a school.
You say hard to understand why they would, but that's quite a common practice. It has its own word. It's doxing. So often when someone posts a message that others find disobliging, what they then do is research who that person is. Sometimes with a view to identifying their employer in order to contact them.
Yes, yeah, I see that.
And in fact, we'll come later to the Amuba case, which is not on all fours, but essentially an example of precisely that kind of thing.
Yeah.
It was someone who had posted a social media message while still at university, and in her subsequent career had it surfaced and circulated and made an issue of controversy.
Yes. Well, anyway, thank you. These are helpful, but they're secondary to your main point.
I agree, yes.
Yep.
So just moving on very quickly through this brief tour of the tribunal decision, you'll see at paragraph 60, and at 53, before we go to 60, they hit the main issue from our point of view, which is, in a direct discrimination case, the question of causation. So they set themselves the task they have to determine. They say, we have to determine the rationale for that treatment. And that...
So did you say paragraph 60?
Sorry, 53.
Oh, 53, I'm so sorry.
I corrected myself, but probably too quietly.
Yeah.
So paragraph 60 is where you'll find their conclusion that the language of the post is florid and provocative. And I will come back to the post in the context of subsequent submissions, but I'm not inviting you to go there now. And they also go on at paragraph 60 to say the school considered that the consequence was that the reader, such as the complainant, might conclude that someone who associated herself with such a post, as Miss Higgs had done, not only felt strongly that gender fluidity should not be taught in schools, but was hostile towards the LGBT community and trans people in particular. This is the first indication of a very significant point that the tribunal is taking. So quite a lot of what you heard Mr. Adair say to you is that this is someone who's being treated less favourably because of their beliefs. It's simply not what the tribunal decides. They don't decide that she's treated less favourably because, for instance, she doesn't believe that a marriage between two members of the same sex is equal to that of a marriage between a man and a woman. It's because the manner in which she has expressed herself could, and in fact did, lead reasonable people to conclude that not that she held that core belief, but that she was either transphobic or homophobic or both. And those wouldn't, we say, be positions that would attract protection. So the essential problem, from her point of view, and part of the essential problem with Mr. Adair's submissions, is that he misstates, we say, what it is the tribunal concluded the reason for the treatment was. It wasn't her beliefs, it wasn't the manifestation of her beliefs, it was the fact that the manner in which she manifested it led people to think she had different, and we say indefensible, beliefs.
But isn't the effect of the EAT's judgment, which is not challenged, that that's a false distinction?
Yes,
That the reason, or at any rate something sufficiently closely connected to the reason, was simply the expression of the beliefs. And you can't say, yes, but the school didn't mind the expression of those beliefs, it minded how they might have been interpreted by others.
It may or may not be. When we look at the remission question, I'm not sure it's entirely clear, but it's certainly possible. That what it is clear is that the Employment Appeal Tribunal determined that the causation conclusion couldn't stand, and that the causation conclusion couldn't stand because they hadn't considered justification.
Yes, I see. Well, you're coming to that as a separate heading, but thank you.
So they go on in the paragraph 61 at page 103 to say the act of which we concluded Miss Higgs was accused and eventually found guilty was posting items on Facebook that might reasonably lead people who read her posts to conclude that she was homophobic and transphobic. And then on at 61, that behaviour, the school felt, had the potential for a negative impact in relation to various groups of people, namely pupils, parents, staff, and the wider community. And pausing there, when we come in due course to look at Article 9.2, the protection of the rights of others is one of the bases on which you can interfere with a right to the expression of a religious belief, manifestation of religious belief. And you've already indicated you're going to be looking at the dismissal letter in some detail. When you do, you'll see that there is a section headed Human Rights, and in the last sentence of that section, that part of 9.2 is specifically relied upon by the school in the dismissal letter. So it looks as if, although they're not being asked to justify in the strict sense of applying a 9.2 argument and a Bank Mallet test, they have in mind, as it were, the language that the article invokes.
Was there any finding by the EAT that the content of the posts might reasonably lead people to conclude that Mrs. Higgs was homophobic, transphobic, or both? All that's clear to me, at any rate, is that the anonymous complainant parent considered that the views were homophobic and transphobic. And the panel appear to have found that a reasonable reader might take that view.
Yes, I'll have to think and have a closer read, but you're right that the passage I've just read to you does not go that far. So what it's doing is summarising the school's view. And the reason for that, I think, is clear, because they're focused on the causation question. In other words, they're asking themselves, what's the reason why? What is happening in the heads of the school at that point? And ultimately what the tribunal decides is that the causal link is missing. So for that reason, the justification issue and an objective assessment as to whether or not the messages would have the effect that the school considered they had, the consequence that the school considered they had didn't arise for the purposes of the tribunal's decision. It's one of the reasons that the EAT has decided to remit it. In fact, is the reason why the EAT has decided to remit it. So the issue that you posed to me, my lord, doesn't arise on the approach that the tribunal took, treating it as a pure causation issue. So two more points very quickly. Also at paragraph 61, the school felt that the behaviour had the potential for a negative impact in relation to various groups of people. At 62, Ms Higgs had made it clear that she had no intention of desisting from making any further such posts in the future. And when you look at the dismissal letter, you'll see a section headed language, and that is dealt with there. Then at 62, they say this: Mr Condon told us that had those beliefs been simply stated on her Facebook page in the form which they appear in paragraph 30 above, no further action could or would have been taken against her. We accepted his evidence to that effect. I think this is where the point that was put to you a few moments ago about if it had been put in the language of the pleading, it would have been fine. It seems to me that what is being made clear here is, having already identified that it's not her actual belief that is their reason for action, this is the tribunal making it clear that it's not the manifestation of her belief that is an issue. In other words, they're saying she can manifest her belief without that being a problem for the school. If it's not the belief being manifested that is the issue, what is it? And the answer is that the manner in which it is manifested creates the impression that she holds different beliefs, as I've already indicated and as the tribunal has already found.
But do they actually find that? And that was my last question.
So at paragraph 64, you'll see they say, in short, that action, being the dismissal, was not on the ground of the beliefs, but rather for a completely different reason, namely that as a result of her actions, she might reasonably be perceived as holding beliefs that would not qualify for protection within the Equality Act. And as we say, beliefs that she denied having. So I think they do decide it, and they decide it there. They're saying it's not her beliefs that are an issue here. It is the perception that she holds other beliefs that is the problem.
I mean, would it have been enough for the school to write and say, well, the complainant takes the view that you're expressing homophobic and transphobic views?
No, that's why I think... Sorry, I didn't mean to speak over you, forgive me.
Yeah.
No, it's why the word reasonably appears in paragraph 64. So they're not simply saying an individual has perceived this. They're saying it could reasonably be perceived in that way.
The panel?
Yes.
So the panel took the view that a reasonable reader might consider that Mrs. Higgs was expressing homophobic and transphobic views.
Is it really the panel taking that?
Well, wondering
Which
whether I
panel-
meant
which
the same
panel
thing
are we
by
talking
panel
about?
that you meant by panel.
Mr. Conlon's panel.
Mr. Conlon's panel.
He was a panel, he wasn't an individual. I'm sure you're right.
Yes.
Yes, I just hadn't picked that up. Yes, you're quite right. Him and two fellow governors. Yep. Okay, so that's the panel. Yep.
At 65, there's the point about what a reasonable employer may have done, the unfair dismissal point. It says a reasonable employer might have taken the view that justice would be served by her or the school, making it clear that if anyone thought she held those views, they had got the wrong end of the stick. And that's relied upon, and I will have to address it in the context of the question as to whether or not there's a possibility that a proportionality argument might be determined in the respondent's favour in due course. But I just wanted to make two quick points whilst we're there. First, of course, in unfair dismissal, reasonable employers may differ as to what they think the appropriate outcome is. It's the reason we have a range of reasonable responses. So that you may have an employer who thinks that dismissal is a reasonable response, and another who thinks it isn't, and both those positions may be reasonable. They may both be reasonable employers. The more important point, though, is you'll see at 66, it says that was not canvassed before us, for the simple reason that it was irrelevant to our considerations. So this is a matter in relation to which the tribunal's heard no argument at all from either side.
Why was that? I mean, nobody knew that the tribunal would necessarily take the course that it did. Suppose it hadn't bought the argument that these reasons are distinct from one another, it would then have had to consider, I suppose, whether a proportionality arose at all, but on the basis of Page, arguably it did. And then it would have had to consider whether it was in fact proportionate. So you might have thought that his arguments were canvassed.
Well, I'm not sure that would have been the way forward. In a moment, what I propose to do is just to give you a sort of very brief taxonomy of different sorts of situations that might arise and how they tend to be dealt with. If what the tribunal had concluded is, we're not buying this at all, we think that looking at the message that you put out on Facebook, it seems to be entirely clear that they cannot be meaningfully separated from the belief itself, then they would conclude that there'd been an act of belief discrimination. To avoid that conclusion, there has to be a separate something in the mind of the employer to avoid Section 13.
Do you say, on a pure separability analysis, you say once, if they'd gone the other way on the point that they decided at 63, then that would have been the end of the case. Questions of fairness, proportionality wouldn't have arisen.
Yeah, so if they had decided, the real problem here, what they're really upset about is that you hold a belief, say, that same-sex marriage is not an equal form of marriage. That's a straightforward direct discrimination case. If they had decided, you can hold that view, that can be part of your forum internum, you must never express that view out loud. It's then going to depend on a number of other circumstances have to be looked at, and I intend to take you through different kinds of cases.
Yeah, but let's not anticipate you're going to do it properly in a minute, so thank you.
I'm grateful. Excuse me. They then go on at paragraph 70 to touch again on causation. You'll see that what they say is that it was possible to see some sort of connection between her beliefs and the treatment she'd received. The posts in question clearly express those beliefs, both in relation to same-sex marriage and gender.
This is in connection with harassment, where the statutory test is different because it's a test of relatedness rather than just causation.
It is, although I'm going to suggest to you, subject to the same separability analysis as any number of authorities, including most recently Amuba, recognises. However, as we have said, her treatment was not a consequence of her expressing those beliefs in a temperate and rational way. Rather, it was because the school felt that the language used in those posts might reasonably lead someone to read them to conclude that she held her views homophobic and transphobic that she explicitly rejected. When I come to Page, which I must do so shortly, there's language used in Page about what Mr. Page had to say on television, about how it might be apt to mislead, is the term phrased.
Yes.
Others into thinking his views were other than the narrower views that he might have had. One of the reasons why it's decided by the Court of Appeal in Page that there was no breach of the convention is because he expressed a, quote, suite of views on homosexuality that might create that effect, that impression that he had a hostility to homosexuality.
We'll have to look at the exact context in which we said that, but yes.
So that brings us finally to paragraph 72, which is where they conclude in relation to harassment that the the causal nexus is not made out. And it's of course that causal nexus question that the EAT considers the tribunal got wrong. Now, I said I wouldn't take you to their analysis because it seems to me that it's clear and I think uncontroversial. Why did the appeal tribunal decide to remit? Well, that's at paragraph 89 at page 80.
And you mean specifically to remit or to find an error of law?
Well, I'm skipping the error of law, but I
Yes, actually, no, that's fine.
on the basis that it seems to be clear that...
Carry on, yeah.
Yeah. So 89 at page 84. That's where the argument starts, and you'll see the argument that was put to the tribunal below, or at the bottom I should say, from this dizzy height. The claimant says that although the ET failed to undertake the task thus required of it, had it done so, it's apparent that it would have found the limitations imposed by the respondent in particular, in dismissing the claimant from her employment, were disproportionate. As a less intrusive measure, it could have been used without unacceptably compromising the achievement of the respondent's objective. Specifically, the claimant relies on the ET's observation that, had this been a claim of unfair dismissal, it might be contended that there was a different course of action the respondent could have taken. And at 90, the Employment Appeals Tribunal says, though I agree that this reference suggests that the ET might well have found that the action taken by the respondent, at least insofar as the claimant's dismissal was concerned, was disproportionate, I cannot go so far as to find this to be a necessary inference from its reasoning. In particular, I'm bound to note the caveats used by the EAT. It might be contended a reasonable employer might have taken the view, emphases added, and it's clear indication that this is not a matter that's properly being considered. We're not concerned to decide. That was not a subject canvass before us for the simple reason that it was irrelevant to our considerations. The questions identified in Bank Mellat require the ET to undertake an evaluation of the proportionality of the respondent's actions, making a value judgment by reference to the circumstances prevailing at the relevant time. That's not an exercise that can be undertaken on an appeal by searching through the ET's decision for signs of the missing elements to try and amplify these by argument into an adequate set of reasons. And I will, of course, have to address the argument in greater detail later, but it seems to me there's no doubt that the EAT has this point in mind.
Yes, can I just put, but she said that the next next paragraph starts, therefore. Isn't there a slight non sequitur there that may depend on how the case is being advanced to her? It's one thing to say we can't be sure what the tribunal was meaning to say or would have decided. That doesn't stop me, the EAT, saying I am sufficiently confident that this is what it should have decided. The argument may have been being advanced, look, you can see actually they had reached a finding on this, and she says, well, no, they hadn't really, they just expressed some provisional views. The next say, well, maybe they didn't, but they should have, and you should have.
Well, let me take that head on. So the reason it isn't clear what the tribunal would have decided is because they say we haven't been addressed on this at all.
Quite.
But if they were addressed on it, what would happen is that they would be taken to instances of evidence that they had heard, impressions of witnesses that they had formed, documents that were in a bundle that we don't have, witness statements which dealt with matters which again we don't have. The judge deciding the proportionality issue at first instance would have a complete control and understanding of all the matters that might be relevant to that proportionality issue. Where this argument has been advanced before you today is so difficult, is what is said is, well, look, it's obviously easy to reach a conclusion on the question of proportionality and justification now, because when you look in the tribunal decision, there's nothing really on it. But there's nothing really on it because the tribunal didn't consider it. We don't know what the tribunal, which is the body that had been given the job of determining this issue, would have decided, because they didn't understand that to be their task. So the fact
the relevance of that, just spelling it out to make sure I've understood your point, is for that reason, they simply didn't make findings or refer to documents which put the EAT, and you would say us, in a safe position to decide any proportionality question.
Yes. So let me try and make it clearer still. And one of the issues which might be, and indeed will be relevant to proportionality, is how one might objectively interpret the posts, which was the point that was being put to me a few moments ago, and pointed out that the tribunal itself didn't seem to have expressed its own view. But if it performs a justification exercise, that's one thing upon which it is going to have to form its own view. So if one asks the question, could people reach different views as to how offensive this material was, and whether it crosses a boundary that I'm going to have to draw for you shortly by reference to convention cases, it seems to us the answer to that in principle must be yes, unless you can be satisfied that this is a matter on which no reasonable person could differ. We're not really in a position to know what the tribunal, what might have been a possible outcome for the tribunal.
Well, I'm not sure that's your best point, is it? I mean, surely the EAT and we are in as good a position as anyone to look at these posts and form a view as to the effect they could have had on reasonable people, if that is the relevant test.
Well,
you wouldn't need any further evidence about that. Wouldn't even be appropriate for evidence about that.
Spoke across you again. The question then becomes, in effect, whose job is it? And this is a task which is allocated to the tribunal to determine. The purpose of the appeal tribunal and the Court of Appeal is to ensure that the tribunal doesn't err in law in doing so. So, unless it might well be that you would look at these posts and agree between you whether or not you thought they met a particular objective test, the precise nature of which we haven't yet got to. But assume you did. But a different panel might reach a different view. The AT might reach a different view.
We would have to approach it, I certainly said, on the basis that no reasonable person could reach any other view than that this was not a sufficiently offensive. But if that were the view we formed, whether we decided it reaches that quite high standard doesn't depend on any evidence that hasn't been put in the bundles or that might have been referred to in by the Employment Tribunal. It's a matter of educated impression of these posts, isn't it?
Well, let me take that point and say, but then that will be one factor. But there are other factors to take into account. And there will be factors, for instance, earlier you said, well, if we're going to decide the point about whether a tribunal would inevitably have had to have found that each of the decision makers reached their decision on the basis of different reasons, your immediate response, understandably, is we better see the evidence then. Let's look at the witness statements. But that's the problem. The problem is this is a decision which is put into the hands of the tribunal that is intended.
Yes, but it does. I take your point, and these are very thought-provoking submissions. But it does depend on what question we're asking. So we're slightly getting ahead of ourselves. If the question is only the one that I posed to you, are these posts of such a kind that they could not reasonably be taken as expressing transphobic or homophobic views or betraying transphobic or homophobic views? I'm at the moment not sure that we aren't in a position to answer that question, provided we are able to answer it on the basis that this is the only view the tribunal could have reached. If it were, which I'm not sure it is at the moment, some subjective question about what motivated the individual decision takers, then obviously the point you make is very powerful.
Yeah.
You're right to point out that
I myself have said, can we see what the evidence was on the point?
Yeah. Well, can I deal with it in this way then? As bit of what I'm going to suggest is compromise, but may sound like surrender. It must be right that there will be some cases in which it is so clearly beyond doubt.
Yeah.
That's the Jaffrey test. It has to be effectively the
Yeah.
only.
Yeah, that's what I've
option.
been referring to, Jaffrey, but that's
Yeah.
what I've been putting to you. Yeah.
There must be some cases in which that was true. Whether this is one, of course, we'll have to consider. But I do concede that there will, on any issue in which involves an objective assessment, there will be sets of circumstances agreed or inevitably bound to agree, in which it may be possible to reach a Jaffrey compliant outcome substitute. So I'm not suggesting you can never substitution related to an objective.
No, well, that's a very balanced submission. Right, thank you. Well, I didn't know whether it was a digression. It's a point we had to look at some point anyway.
I'm grateful. And I'll come back to it in a little more detail, as I said. I was then going to look at the scope of remission. And may I invite you to look at page 41 of the core bundle.
Yes.
So it's really paragraph 1. It says the appeal will be allowed and the matter remitted in accordance with the reasons provided in the judgment handed down for the determination of the question, so one question, whether the respondent's actions were because of or related to the manifestation of the claimant's protected beliefs, or were due to a justified objection to the manner of that manifestation, in respect of which there was a clear legal basis for the claimant's rights to freedom of belief and expression to be limited to the extent necessary for the legitimate protection of the rights of others.
Yeah.
So
It's a slight boiling down of what appears in para 95.
So
Or maybe it may be actually it's the exact words, but yeah.
what we have here is a hybrid test. So on its face, what it is sending back to the tribunal for determination is an issue of causation. So the determination of the question of whether the respondent's actions were because of the manifestation or the protected beliefs or related to for the purposes of harassment. But bolted onto it as the alternative is either it's because of the manifestation or the beliefs, or you then have to ask whether or not it was because of the manner of the manifestation, so far so good and orthodox we say, in respect of which there was a clear legal basis for the claimant's rights to be interfered
For a
with.
clear legal basis for their rights to be limited.
Yes. And that's the 9-2 consideration.
Well, it is a hybrid, and it's a hybrid which it might be said is forced on everyone by Page.
Well, to which I will come shortly. But and these are difficult legal issues, as you identified. My purpose at this point is not to, as it were, get into them and give you the answer, because that would be Mr. Nelson. But to crystallise it down to, as it were, the abstract proposition, the way in which freedom of speech rights, I agree with Mr. O'Dare on this, are protected is different to the way in which we combat discrimination. And this is something which Advocate General Sharpston discusses in her opinion in the, I'm not going to be able to pronounce this correctly, the Bougnaï decision. She talks about how you can have a discrimination model, but the convention, rather than having a discrimination model, has a restriction model. So you say, has the right been restricted? And if it has, then justify it. Whereas discrimination focuses on why you are doing the thing that you did. So the way of testing it is that the traditional comparator wouldn't produce an answer to this question. So the traditional comparator in a belief case is, what if someone had said the same thing but didn't share your belief? And if the answer to that is, well, they'd have been treated in exactly the same way, there's no discrimination. Or at least there's no direct discrimination. I should make that clear. But that answer wouldn't suffice for this remitted question.
You're going to make this submission properly in a minute, are you?
Yes.
It was, you're just at the moment saying it's another difficulty with the remittal.
I can't ask you to interfere with the remission, but I look at the remittal because it very neatly identifies where we say the disjuncture is, where the hybridization happens and what the impact of it is. It turns a discrimination test into something which is no longer looking fully, squarely, and solely at discrimination. So underpinning that is, to our mind, a justice issue. If a tribunal is going to make a finding that almost invariably an individual has made a decision which was discriminatory on grounds of belief or on grounds of religion, and they are going to have the associated sanction and the both social and legal, then that ought not to happen as a discrimination finding in circumstances where they can truthfully say, I would have treated anyone else in the same way. The discrimination protection shouldn't be, as we think it is as a result of this reading of Page that is included in this statement, hijacked for the purposes of providing a remedy for what is in effect a direct breach of the convention right. So what I propose to do is to take you to one or two of the authorities, principally domestic authorities, to trace how this is being dealt with, and then on, as you would have expected, to Chondle and Wasney and then Page, to put it in the context of to how this has been approached.
I'm sure that would be helpful.
I'm grateful. So I said I would try and give you, I hope, a simplifying taxonomy. There are two simple cases at either end of the spectrum. One end of the spectrum are cases where it is absolutely clear that someone has been less favourably treated because of the belief itself. So imagine, for instance, an employer finds out that you're opposed to same-sex marriage, calls you in for a disciplinary and says, I do not want people who are opposed to same-sex marriage in my business. You may never have said this out loud, but I've discovered that's your belief, you're sacked. Absolutely, straightforwardly, very clearly an act of direct discrimination. Manifestation is where it gets more difficult. I said there was a simple case at the other end of the spectrum. There are cases where the belief has been manifested and it's causally relevant in a but-for sense, but the reason for the less favourable treatment is found not to be the manifestation. And Amoeba is an example of that. Perhaps I can take you very quickly to Authorities Bundle 9, page 11. Oh, not 11. 12. So this is a post-Higgs EAT decision by Mrs. Justice Ely on a manifestation of belief case dealing with the question of the reason why and causation. It's a case involving a social media post which expressed a belief about sexual orientation. That belief was a protectable belief, and that you'll see at paragraph 43 of the decision, page 18. At the end of paragraph 43, you'll see.
Hang on 1 second. Yeah.
So what happened is the claimant had accepted a role in a production of The Colour Purple, and the role she was playing was someone who had been engaged in a lesbian relationship. Another actor, if I remember correctly, dug up her university posting, and there then followed what's described as a media storm. And she was asked whether or not she dissociated herself from the views that she had expressed about homosexual acts being sinful, She said that she did not. And what then followed was that she lost her acting engagement. Her engagement was terminated, and her agent terminated the representation contract too. So she alleged that she'd been the victim of an act of direct discrimination. The actual outcome in this case is that Judge Eady concluded that neither the belief or the manifestation...
Eady,
sorry?
Mrs. Justice Eady.
Mrs. Justice Eady, sorry.
You said Judge Eady. Don't worry, I'm just teasing. Keep going.
Neither the belief nor the manifestation was an operative reason for the decisions complained of. So you'll see that at paragraph 158 at page 33. So it wasn't enough in this case that the manifestation was a but-for cause, in the sense that had she never made the posting, it wouldn't have surfaced, there wouldn't have been a media storm, she wouldn't have been dismissed. The EAT was satisfied that it was sufficiently remote causally, that she was not directly discriminated against in relation to the termination of her engagement or representation by the agent. So there's no Bank-Mellat test applied, no question of whether or not it had been prescribed by law. So that's, as it were, the opposite end of the case. There are, the opposite end of the spectrum, there are cases which are about manifestations, where the manifestation is a part of a causal chain that results in the less favourable treatment, but it's sufficiently remote that it doesn't count, doesn't raise Article 9.2 issues. So then we get to the problematic ground, which is in between those two, dealing with cases where the reason is broadly the manifestation. Now, I'd say that not intending to create any kind of legal test or category, but that's just a broad heading under which a number of different possibilities are lumped. But trying to deal with them logically, there will be, first, cases where the manifestation reveals the belief, but it's the belief that's the real reason. So to go back to my first example, you come into work wearing a I believe in same-sex marriage t-shirt, and your employer says, "I never realised that's what you thought, now I know you're sacked." So the manifestation is really the vehicle through which your belief is revealed, but it's the belief that is the reason why. And those will obviously...
Hang on 1 second. Yeah.
That's a straightforward, we say, Section 13, direct discrimination based on the belief as the reason. So you might get a slightly different situation in which the employer objects to the manifestation of the particular belief. So they say, you can come in wearing a t-shirt saying, "I support same-sex marriage," but you better not come in wearing one saying that you don't. I don't mind if you believe that, but you absolutely must not manifest it. So the objection is to the manifestation specifically. We think that is still direct belief discrimination, because although the employer is focused on the manifestation, they're distinguishing between different manifestations, and the reason, the basis on which they're distinguishing between them is which belief they manifest. So it's still a belief discrimination case rather than a manifestation case.
It's not so much that it is a belief case but not a manifestation case. It's a case where there is no distinction between the two.
Yes. So that's an important observation for a reason I'm going to make clear in a moment. Another possibility is you have an employer who says no one must manifest any belief.
Hang on, sorry, just to make a note.
So sorry, do go on, yeah.
Yeah, so effectively plain t-shirts only. I don't want to hear your belief one way or the other on anything. No manifestations of your beliefs, please. If that's going to found a discrimination claim at all, it will be on an indirect discrimination basis. So that there may be some people who say, well, this refusal is applied equally, but it affects me particularly harshly because. So you can see, for instance, that if you had absolutely no manifestation of any kind of belief or otherwise, that might cause problems for Sikhs. That's the traditional example given. That might be indirectly discriminatory. And then we get to the last possibility. The employer doesn't object to the manifestation of the particular belief or to the belief, but objects to the manner in which it is manifested. And the question is, how do we then deal with that? And there are really, we think, on the authorities, 3 possibilities, one of which, the last of which is Page, which we say is not the appropriate approach. So the first way of dealing with it is to deal with those cases.
Let's suppose the t-shirt example lends itself particularly to this, but manner. Well, suppose it just used obscene language. I forget which way your example is. It's someone who's opposed to same-sex marriage. Is that right?
Yes. So, well,
if the t-shirt said, "I asterisking believe in same-sex marriage." It's not a very good example. I'm having to work with your example. But say, look, I don't mind you saying this, but don't use that word.
Yes. So, for instance, having in mind the Facebook posts, if it said, as I've heard said, the parents of gender fluid children are child abusers. So you might believe that sex is innate, and the notion of gender fluidity is an absurd construction or a mental derangement, as it appears to have been put in the Facebook posts, and that those who foster it are engaging in a form of child abuse. That might be to take the gender essentialist position, but express it in such a way that it is likely to cause sufficient offence to be a real problem for an employer.
It's a slightly more subtle and complicated example than my one, but perhaps for that reason it's a better example. But can we just keep my one in mind as well, where you just express your belief, but you do so using obscene language?
Yeah.
And particularly perhaps if it's in an employment context, I just don't want t-shirts using that word in my. The t-shirt happens to be about same-sex marriage. That's a pretty clear case of the manner in which something is expressed. And anyway, sorry, you were about to say there are 3 possibilities.
Well, the first is, as I come to that, let me say, I think for a lot of employers, that's probably where they live, as it were. That they will turn to their workforce and say, not troubled by whatever you believe whatever you believe. I'm not particularly troubled by you manifesting it. You know, if you want to wear a hijab, if you need to wear a turban, if you want to wear a t-shirt that expresses your particular political view, I don't mind. But bear in mind that one of the things I have to do is ensure a workplace in which people don't feel harassed or excluded or unsafe, that you are interacting in a way which has more to do with doing work than the kind of cockpit of intense political and religious debate. Where I do draw the line is if you manifest in a way which is offensive or marginalises others or treats them in a way which they would perfectly reasonably find to be unnecessarily offensive, that I don't want. That, we think, is really another indirect discrimination case, that most of the manner of manifestation cases are really better analysed as indirect discrimination cases. They're employers saying, our rule is do what you want, but don't be offensive, effectively. And it's an oversimplification. But
How do you formulate that as an indirect? The rule, the PCP then would be
don't be offensive.
Don't be offensive, and that is disproportionately affects people with very strong political beliefs, because people with very strong political beliefs tend to wish to express them offensively. Is that one ways that could cause offence?
Well,
it's a pretty artificial. Is it? Or is it some other analysis?
Well, I can give you a less artificial example. So, wasteny, we say, is better thought of, or would be better thought of, as an indirect discrimination claim. So,
well, I can't remember the wasteny, but we'll come to that.
So, wasteny is proselytisation. So, you would have a rule. So, you've got your PCP, which says you can't seek to proselytise in the workplace. And a Christian may well say, well, look, God's told me I must. I have an obligation in relation to the souls of others. If I let others die unsaved, that's on my ticket on Judgment Day. What I am told is that it is my obligation to seek to try and save souls around me. And the employer says, but not at work, thank you very much, that's my rule. And the employee says, well, that's not what him upstairs is telling me. That must be done. So it's an example of, obviously, proselytising is a manifestation of your belief, but there's a question as to whether it's appropriate in the workforce, in the workplace. The employer says it is not. What happens in wasteny is that rule is broken and they're dismissed.
Yes, I see.
So I'm not, as it were, plucking, I hope to show indirect discrimination out of the ether. Can I invite you to look at bundle 5 of the authorities and at page 12?
Sorry, of course I will if you like, but it would help me as you got this far, just to have in headline terms what your 3 possible analyses of the manner cases are. 1, indirect discrimination.
Yes.
2, or if this isn't helpful, I'll hold
I'm
my
more than
breath.
happy to do it. So 1, indirect discrimination.
Is it anywhere in your skeleton argument, Mr. Jones? I'm only asking because it's easier to see it in writing than.
Yeah, it would be. It's not. I'm afraid.
It's not.
So
I suspect we could be asking that question quite a lot, Mr. Jones. but we won't.
maybe. The second way of looking at it is to say, well, in such cases, in manner cases, if the operative reason is the manner of the manifestation, then that's causally separable.
So that's classic separability. That would be expressing a political view, but using swear words.
Yes.
Yeah.
And we say that's the approach taken, for instance, in Kong in relation to whistleblowing.
Yeah.
And then the final possibility is to treat them as direct discrimination cases, but then to drag in manner of manifestation and not just manifestation, and either do that but ditch justification as an issue, or find some way of hammering Article 9.2 justification into Section 13.
Yeah.
And we say the Higgs EAT reading of Page, as it does the latter, but you'll see some of the submissions from interveners say, well, but just make it a Section 13 case and don't bother yourself with justification, because you're entitled to have, in effect, a broader, deeper protection under the domestic legislation, even if it goes further than the convention requires.
Yeah. You haven't used the magic word Section 3, but in practice, that is how you would do it.
That's
You may say it can't be done because Section 3 only works so far as possible, but that's, I think, how we thought we were doing it in Page.
yes. You will hear Mr. Milsom say it can't be done, and you'll hear, I think, the Commission say it can't be done. Another thing we say is, well, you don't need to do it because you can deal with it by means of indirect discrimination.
Or, in a proper case, genuine separability. You're not, I think, mounting any, you couldn't anyway, but if I'd let you make submissions on things that were decided at this level,
you don't want to make an attack on separability in an appropriate case.
No, I certainly don't. So,
Yeah.
from our point of view,
Can I just ask, if you say indirect discrimination is one way of dealing with this, and I know that's said by others as well, I, for one, would want to understand how that would really work on the facts of this sort of case,
yes,
where there's at least some indication or argument that if it was perceived that the opposite view was being displayed, then there wouldn't have been any objection to it. In other words, you're saying objectionable manifestations could be dealt with as indirect discrimination. I'm just asking, one needs to consider whether that would work in all cases,
yes.
including actually the facts of this case.
It's harder in this case because the reason given for why a different view might be acceptable is, if I remember Mr. Condon's position correctly, is because the government was requiring them to teach that view.
Well, I suppose I'm just actually referring to the facts of this case to say maybe answer A, the first of your three alternatives, doesn't seem to be a comprehensive answer.
Well, it may not. We'll need to think about it,
Yeah.
and we may need to explore the boundaries of it. There are certainly cases, and it's not an entirely uncommon experience in discrimination law to find cases which one might.
Sorry,
interpret
again, you
either way.
speak up a bit.
Sorry. Excuse me.
Don't kill yourself, but or ruin your throat.
It's not entirely uncommon to find cases in discrimination which are analysable either way. So you do see cases regularly in which people say what has happened is direct discrimination, but if not, it's indirect discrimination.
Well, if you say analysable either way, that's only because it's uncertain which is right. But
Exactly.
there's clear authority that in any given fact situation, it can't be both.
I agree. Yes, so it may be analysable either way, but there's a correct analysis at the end of the day. So I'd need to think about your specific example. May I invite you to look at the Liddell case in the Court of Appeal. So
Where did we find that?
that is in Bundle 5. Page 12. So, Miss Liddell was a registrar, and she refused to conduct civil partnership ceremonies. And that was a manifestation of her Christian belief. And we can see that at paragraph 35 at page 22. And interestingly, to pick up the ladyship's point, she was, of course, in a position in which her refusal to conduct civil partnership ceremonies because of her religious beliefs was one side of the argument. Others, of course, favoured same-sex civil partnership and were prepared to do them. The rule was that they should all do them.
Yes, but this naturally falls into an indirect discrimination category. That's my point, because it's a single rule.
Yes. So, but I'm not entirely clear why my formulation isn't also a single rule.
Well, I'm just saying, on the facts of this case, how would you apply that?
What you would say is we have a rule which is that you mustn't express your beliefs in a way which is going to create the offence that this expression did. It's the offensive boundary. So at paragraph 29, at page 21, they're considering the Employment Tribunal's finding on direct discrimination. And they go on at 30.
So just give me one moment, Will.
Yes, sorry, I'm just checking something on the head note. Which paragraph are we on?
So it's 29. The tribunal concludes that Ms. Liddell suffered direct discrimination on the core issue, namely being required by Islington to conduct civil partnerships. They say, as the Appeal Tribunal said in ISJ's impressive and cogent judgment, that conclusion was quite unsustainable. As he went on to explain, Ms. Liddell's complaint is not that she was treated differently from others, rather that she was not treated differently when she ought to have been, and her complaint was about a failure to accommodate her difference, rather than a complaint that she has been discriminated against because of that difference. The ISJ said in the next paragraph of this judgment, cannot constitute direct discrimination to treat all employees in precisely the same way. This error also applied to virtually all of the other findings of direct discrimination by the tribunal, as summarised in paragraph 90 above. And then they go on to say another similar error of law in the tribunal's approach, which applies to virtually every allegation of direct discrimination, was identified by the Appeal Tribunal, was expressed by ISJ in these terms. Even if there is sufficient evidence from which an inference of discrimination could be made, the allegation requires consideration of the explanation given by the employer for the less favourable treatment, as if the tribunal had been satisfied that the reason is non-discriminatory, even if in other respects the conduct is unreasonable, then no discrimination has occurred. So a couple of things to draw from that. The first is, what the tribunal finds in this case is that anyone else who had expressed those views would have been treated in the same way. The problem was not her beliefs. It was what she said and how she said it, and the fact that it had created the impression that she was expressing transphobic and homophobic views. Anyone else who had done that would have been treated in the same way. So it is to that extent, we say, comparable to Liddell. It's a question in which, it's a case in which what is being said on her behalf is not, I should be treated like everyone else, but because I am expressing a political view, I should be treated differently to how you would treat other people. That there's a special protection for the expression of this political view. By all means, sack someone else who sends out a Facebook post which incorrectly creates the impression that they are homophobic or transphobic, but not me, because what I'm doing is expressing and manifesting my religious and political views. So that, we say, is effectively the error that is identified in Liddell. It's the reason why the ordinary direct discrimination comparator doesn't produce the result that the claimant would want. Because anyone else who did what she did, with the consequences that it had, would be treated in the same way. So the way sorry.
I'm not sure that works. Let me have the. Well, if she had in fact expressed transphobic or homophobic views, that would be direct discrimination. Only it wouldn't be because it's a bad example. I mean, the treatment would be the same if she had in fact expressed transphobic or homophobic views.
Well, the comparator would be someone who said the same thing but didn't have her belief.
Well, the problem is that...
I'll let Melanie go first.
I think your proposition presupposes that what the post actually did convey were homophobic and transphobic views rather than views associated with her beliefs. There's a very clear reference to her beliefs. So whilst I can see your point disassociated from the actual facts of this case. I'm making a point about the actual facts of this case.
Well,
I can see, you know, general rule that employers say no one must express homophobic or transphobic views. Don't mind about what your underlying reasons are. I can see your argument, but that's not this case.
but with respect, I'm not sure that what you're putting to me is this case either, because she isn't dismissed for expressing transphobic or homophobic views. She's dismissed for expressing views that could reasonably be understood to have that effect. So what I'm suggesting is that anyone else who had expressed views that could reasonably have been interpreted in that way, but without thereby manifesting any belief that they held, would have received the same treatment. And that's, you can see how the tribunal gets there. It says, well, it's not the belief, and you could perfectly happily manifest your view if you wanted to on Facebook, but not in this manner, not in the manner which creates the impression that you're homophobic and transphobic. It's why the tribunal goes through, it seems to me, those stages of analysis of Mr. Conlon. And
is it relevant for this submission whether we take a view as to whether it could have been properly viewed as homophobic or transphobic?
I think not for this reason. If one looks at the quote from Elias J. at paragraph 30, he's saying for the purposes of direct discrimination, the question is the reason non-discriminatory, even if in other respects the conduct is unreasonable? So if you decide to treat someone less favourably for a non-discriminatory reason, even if it's unreasonable, your treatment is objectively unreasonable, that's so far in all the other cases, that will not suffice. But what you're looking at is whether or not the protected characteristic is an operative part of the reason that the treatment is being meted out. And because that doesn't work on the direct discrimination comparator, it's why in Liddell they move on to indirect discrimination. And you can see that that makes a lot of sense, because instantly they're into the question in Liddell of justification. So the questions as to whether or not objectively the treatment can be justified don't go unaddressed in Liddell, but they are addressed in the context of an indirect discrimination analysis and not a direct discrimination analysis.
And just tell me again, on the facts of this case, if an indirect discrimination claim had been brought, how would it have been formulated? What would the PCP be?
Well, I'm acting, in this scenario, I'm acting for the claimant. I say, right, you've imposed a PCP. I look at the dismissal letter and I say, you've obviously imposed a PCP that no one must express views in a manner which might be capable of being interpreted as being homophobic or transphobic. Then what I might say is, well, I have views, for instance, on gender essentialism and views on same-sex marriage, which it is important for me to be, she says, to be entitled to express. They raise a risk of being interpreted in the way in which you have forbidden, which the expression of other views might not. So that puts people who hold and express my views at a particular disadvantage.
Would it have been relevant to consider a hypothetical comparator case of somebody with exactly opposing views to those of the claimant, who put out Facebook posts saying that J.K. Rowling or any other well-known protagonist on the other side of the argument holds repulsive views?
Well, it might be. I'm not sure that I could hand on heart say that there would be no material difference in those circumstances. If you're constructing the hypothetical, you obviously cleave as closely as you can to the specific facts and seek to remove the protected characteristic, which can be done, but it would be an evidential comparator, I accept. you can see it arises in other circumstances too. So almost every employer will have a policy, an equality policy, which requires equal treatment, for instance, on grounds of sex. So, speaking for a moment as a Roman Catholic, an absolutely strict application of Roman Catholic teachings on the relative position of men and women and who can teach and who can't, who should be master of the home and so on, a lot of that would be very difficult to reconcile with the sort of modern equality and diversity approach which is adopted in organisations. And if I express those views, that might well get me into trouble. But equally, there are a lot of people who hold deeply sexist views which are completely untethered to religious belief. So if I and a straightforwardly sexist colleague both express the same views, there's no reason, it seems to me, why we should be treated differently in those circumstances. But what's really been asked for by Mr. Adair is that we should be treated differently. That by all means just go ahead and find that they've breached the policy and you're in trouble. But in my case, only do that if you can be satisfied as an employer that the 9(2) conditions are met. In circumstances where what is also urged upon you is so important is freedom of speech and religious belief that it's only in wholly exceptional circumstances that you should find that they are. And that, I think, is specifically what they are saying, what is being said in Liddell is not an appropriate approach. And indeed, you'll recall in McFarlane in the Court of Appeal, Justice Laws considered specifically whether or not there was constitutionally a basis for giving religious beliefs, as it were, a kind of an additional protection, and concluded that there was not.
Hang on 1 second. Oh, I'm so sorry. We're so carried away by your submission. This is the time. We will have to rise very shortly because there's a swearing in that we wanting to attend.
Well, that's a convenient moment.
It's quite a convenient moment anyway. Thank you. Really, whatever happens, we've got enough time tomorrow.
Yes.
I know you won't take longer than you need or than we encourage you to take.
Thank you.
My Lord, may I just mention one thing briefly? I don't call you back. This, that from the appellant's point of view, there are going to be two sets of submissions, not very much flagged up by skeleton arguments. That's both Mr. Jones and also the Equality and Human Rights Commission. And I understand why that's so in both cases, but it does put me at a little bit of disadvantage unless I'm given a very substantial right of reply, and that's the.
Well, you have a right of reply, full stop. Say what you mean by very substantial. Are you trying to say you may need more time than one would normally think?
I think that's.
Well, that may turn out to be the case. Let's bear that in mind. I think it's fair to say that I don't recognise many of Mr. Jones's submissions from the skeleton argument, and there may be some points also made of the same kind about the human rights submission. We'll have to wait and see. Well, everyone will bear that in mind, is all I can say. Thank you.
Court rise in favour.